name's Antoine Tinnion, barrister at Trinity Chambers. It's my privilege and pleasure to tell you about redacting key documents at trial. I've tried to sex it up and give it an interesting title, the document, the whole document, nothing but the document question mark, like an Agatha Christie novel. But I'm afraid to say the subject matter is somewhat more mundane than that. Listening to Simon's talk and then mine is to go from the sublime to the ridiculous. It's not an entirely law-free zone. In fact, there's been 2 Court of Appeal judgments on this general subject matter in the last 2 years, but I confidently predict that you'll never see the Supreme Court ever address anything as vulgar as getting your black pen out and putting some lines through a piece of paper and the Lordship's working out whether that is an appropriate thing to do or not. I trust everybody here knows what a redaction is, but just in case you don't, and I haven't prepared a slide because it's pretty obvious, the usual thing is a big black bit of text or blocked out text in a document you're looking at on screen. That's the obvious indicator of redaction. Sometimes, much more rarely, you see an old 1970s CIA style redaction where it's been whited out and the word redacted is there, and that makes it look sexy and interesting. But also watch out for the stealth redaction. The stealth redaction is a redaction which is not obvious on the face of the document you're looking at. Suppose, for example, you get a contract and it's produced in Discovery and it has 25 pages and you get 23 of them, but you're missing 2 pages. You might assume, oh, printing error. Sometimes yes, sometimes not. Those pages may be deliberately held back and you don't even see them when the document is produced. So that's what redaction is all about. So in terms of it being a practical topic, if you're a commercial litigator, I'm sure you probably already have seen redacted documents. You can pretty much guarantee if you haven't, you will see them during the course of your career. If you're the party who wishes to make a redaction or the lawyer's acting for them, it may be because your client wants to keep their own private business private and only produce in litigation the bits which they absolutely have to produce. There may be confidential information they don't want the other side to see. There may be information which is not confidential, which is frankly embarrassing, and they prefer it not to go out into the public realm if they can get away with it. The other side of the coin is you may be acting for a party who's receiving documents, and you get some documents in there which are redacted. Sometimes it may be obvious why things have been redacted. If it's a name or an ID number or something like that, it's not something you're worrying about. But other times you may be thinking, well, why has this been redacted? What's going on here? Is something relevant to this claim which will help me being hidden? So you've all got in the handout a somewhat more learned discussion of redactions, which sets out the legal basis for what I'm saying. But in terms of practical, day-to-day matters, the issue of whether a redaction is allowable or not, and if it is, what you've got to do about it, really boils down to 3 things. First of all, whether the document you're talking about is one the court is being asked to construe or not. I'll come on to that in a moment. The second issue is whether the material to be redacted, said usually text, is relevant or not relevant to the legal dispute the court has to decide. And then the third issue is whether the material text to be redacted has some additional feature beyond relevance or irrelevance, potentially justifying the redaction. I've given the one obvious example here, confidentiality, privacy is another example, but it's not a closed list. Lots of other reasons can be relevant. When does a court construe a document? Because I said that's the first key issue. Well, there's no legal definition of construing a document, but like many things in life, you know it when you see it. And I think the practical distinction is when the court is being asked to determine the legal meaning and effect of a document, and that is the classic example of construing a document. And I've given 2 obvious and well-recognized examples there. A contract, what is the legal effect of the terms of that contract? The will, what's the legal effect of the will's provisions? That's classic construction of a contract. And I think a classic example of not construing a document is when you look at it just for information. I've given an example of a ledger, and I've given an example of an invoice, but obviously the list is endless here, where everybody knows fine well what the document is, no real job or inquiry of construction at all. You're just looking at it to see what's said on the document. The thing I've mentioned about will is an interesting one because it's a good example of construction of a document, but of course it's a very bad example for the talk on redactions because, as I'm sure you all know, up until there's a grant of probate, wills are private documents. But after the grant of probate, the public documents, you can pay a £5 or a tenner and get a copy of it, and they will not be redacted. So again, it was just an example. But that's what it means. So the first question, is the court, or the document you're looking at, a trial, a document which the court will have to construe or not? When the court is not being asked to construe a document, I'm not saying it's the Wild West, you can't do anything and everything you want, but the starting point is that the party producing that document is allowed to produce it in a redacted form on disclosure, is entitled, at the starting point anyway, to rely on it in redacted form at trial as well. And unless anybody asks them about it, they don't have to justify the redactions as well. That's not to say that they can give no explanation. Parties in litigation, and certainly once the claim has been issued, are of course obliged to comply with the overriding objective, and that means if the other side asks you why something has been redacted, you need to tell them, and you tell them properly, you need to not blow them off as well. But that's the point. If the other side, the side who's receiving the document, don't complain about it, that's basically okay. And the burden will be on that party to raise on a timely basis any complaints about the document. You don't wait till the first day of trial or a couple of weeks before trial to say, hang on, our cross-examination's not going to work because we haven't seen the complete document. And again, the practical point is that if those disputes can't be resolved between the parties of the solicitors talking to each other, the opposing party, that's the party getting the redacted document and complaining about it, burden will be on them to go to court to get an order to get the document in unredacted form. So we move on to the scenario where the court will have to construe a document. The position here is if the only basis upon which the redacting party seeks to redact material or text from that document is relevance, and that really is the only factor, there's no confidentiality concerns, no privacy concerns, then you can't do it. The document has to be produced, and certainly a trial, in unredacted form. And why is that? Because the court has to have the whole document, and it's not for the producing side to unilaterally decide for themselves what is relevant or not relevant in the document. That's a question for the court to determine. I've given you the examples there of additional factors that I've mentioned, confidentiality and privacy. The issue of whether a party would face public embarrassment if a document was produced at court in unredacted form is not something which I'm aware of has been litigated, and I have to be honest, that's quite a difficult question to decide. I suspect probably not. I suspect that wouldn't be considered a good ground for doing it, but I don't know that for sure on any legal authority. So what happens here if the court has to construe a document? The text is wholly irrelevant, that's the words the Court of Appeal has used, and there are additional factors justifying the redaction, confidentiality, privacy, etc. Then in that case, the document used at trial, the one in the trial bundle, can be redacted. But there is an obligation on the party or the party's solicitors, if they have solicitors, to, quote, clearly and fully articulate the basis for the redactions. I don't think as a matter of law or even best practice that needs to be done in a solicitor's witness statement. It can be done in correspondence. The key point is that the explanation of the redactions has to be clear and it has to be full. So that obviously means at a minimum you have to say what's been redacted in at least broad subject matter, and then say with some level of detail the basis for the redaction. Just saying it's confidential, just saying it involves privacy rights will not cut it. It needs to go beyond that. There must be enough detail provided so that if the receiving party is not happy with that information provided, the court can work with the document and that information to work out whether the document should be provided in unredacted form or not. The next scenario is when the material, the text to be redacted, is relevant. And this is obviously a bit of an odd one, because you think, well, how on earth, if something in a document is relevant to the legal issues to be determined in the outcome of a trial, can you or ought you to be redacting it? Well, you can, at least potentially again, because remember that these documents go in a trial bundle, public documents, journalists may get copies of them. Once they're out possibly forever. If the material to be redacted is relevant, and there are additional factors justifying the redaction, you can redact the document, but the court, because the material is relevant, must be allowed to see the whole document. And the normal rule, and I thought this would be true in 99.9% of cases, is that the receiving party, the opposing party, must also be allowed to see the whole document as well. There's a whole myriad of ways you can do that, things called confidentiality rings, or you can say, well, the lawyers acting for the receiving party will get to see it on an eyes-only basis, and they can satisfy themselves as to what it says and that it's appropriate to be redacted or not. So that is the rule or the practice, best practice when it comes to construing documents which are to be redacted on which contain relevant material, but there's an additional factor justifying the redaction. Practical tips. I've said a bit more about this in the handout, but I think there's some obvious things to do. Keep redactions to the bare minimum. Best number, 0. Why is that? Obvious. You avoid collateral litigation. You can have all sorts of headaches and arguments and expensive applications and all the rest of it if you've over-redacted or you've made redactions where you really didn't need to do that. Unless you're a Russian oligarch and have money to burn, collateral litigation about satellite issues is a waste of everybody's money. This is one way of avoiding it. Try and keep your redactions, if you have to make any at all, to the absolute minimum. Timing, I've already touched upon. If you are the receiving party, make sure you get on with it. You will know by the time you get the other side's disclosures whether any of those disclosures have been produced in redacted form or not. And that is your clue to start to know that the clock is ticking. And if you are not happy about the redacted materials, start raising it with the other side, getting the explanation, teeing these issues up if necessary for a court determination of the issue. As I said, and I won't spend long on this, the solicitor's statement justifying the redactions shouldn't be generic, it shouldn't be vague. It's not a rubber stamp process. The court will want a proper articulation of why particular redactions have been made or not. And then finally, and this really comes to, probably if you remember anything at all about this talk, remember this: if you are going to redact a document, make sure you do it right. I said automatic fail if your opponent can still read material text meant to be hidden. I've been around the block as a litigator and a lawyer for not far off 30 years now. And I remember the days when you rarely saw computers on a screen. You get documents in physical form, redactions would be done in physical form, put through a photocopier and then produced to the other side in that form. And very often, if you're lucky, somebody would have a bit of black tape, put it over there and hide it. The lazy strategy was just to get a big black marker pen and scrub over it, do your best job, try and get it look like a rectangle to make it look neat and tidy, hand it over. Unfortunately, or at least a photocopy of that, unfortunately back in the day, even with photocopies of things done like that, very often if you held them up to the light, you could still read the text which is underneath the ink. So that didn't work. And you may think modern computer era, PDFs, software to generate redactions, you don't need to worry about this. You're flat wrong. Flat wrong. 2 examples. One from my career, which caught before it went out the door, but it did happen. Acting in a big class action in the States, there was an expert report about trading in securities, and there was data about the securities trades, the security traded, the prices, the names of the counterparties, the parties to that trade. That was irrelevant information. It didn't matter. What mattered was the trades. I had a number of paralegals spending days going through these documents, redacting them, checked it myself on screen, all looked perfect, saved it to a disk, thought, let's check on that. Put the disk back in the computer. Again, I'm showing my age, it's about 20 years ago. None of the redactions showed up. all of those party names are still there. So there can still be cock-ups with technology. And let me give you a much more recent example, an anecdotal one, but one I have very good grounds to believe is true. A particular party, solicitors in an ongoing case, used a particular piece of software to enter the redactions on the document. You know, you get up there with your cursor, you highlight the text, blacks out. They saved those redactions on with that software, and it was that file which was produced to the other side as a redacted document. Problem was the other side had the same software, and they opened up the document and they were able to remove the redaction because all of the data which was underneath the redaction was still there. So even in today's modern world, with all the sophisticated computer gadgetry we've got, redaction errors can happen. And if you're going to do a redaction, for God's sake, get it right. My tip, it's only a tip, not a guarantee, but if you've done redactions on a computer on a document, so you've got the document in the redacted form you're happy with, what I will typically do is, obviously you save it so you've got your redactions on there, print off, my advice, print off that document in a different bit of software, Microsoft Word to PDF, or there's Nitro PDF is another one you use, but print it off on a totally different piece of software where that other bit of software won't have any of the underlying data or the metadata, and it will literally be a photograph of the document you've redacted. And that seems to me, again, not certainly error-proof, but probably a pretty good way of ensuring that if you're handing over that redacted PDF electronic file, that what the other side do get is the redacted document in electronic form in a way which they can't undo by the click of a button. So that's that. Thank you very much.